Morning, Salome B here, and today I want to talk about qualified immunity. The End of Qualified Immunity by David Finch, and this came out September the 13th, 2018 at 4 p.m. Congress passed a law to restrain government actors. The court should enforce it as written. Okay? I'm going to start off with a story that will break your heart. In the early morning hours of July 15, 2012, a young man named Andrew Scott was up late home with his girlfriend. They were playing video games, and when they heard a loud pounding on the door, alarmed, Scott grabbed a pistol and opened the door. He saw a man crouching outside in the darkness. Scott retreated, gun still at his side, pointing down to the ground. Almost instantly, the crouching figure fired his own weapon. The encounter was over in 2 seconds. Scott lay on the ground dead. The man who fired, he was a police officer. He was at the wrong house. Andrew Scott was completely innocent man who had done nothing more than exercise his constitutional right to keep and bear arms in defense of his own home. That was terrible. As for the officer, well, not only was he wrong at the wrong house, but he had no search warrant either for the correct house. He didn't have a correct search warrant for the house. I'm sorry. He had not turned on his emergency lights, and he did not identify himself as a police officer when he pounded on the door. The officer was never prosecuted. The state ruled that the shooting was justified, in part because it said the police had no obligation to identify themselves. That's number one. Then when Scott's estate sued the officer for money damages, the court threw out the lawsuit. A panel from the 11th Circuit Court of Appeals affirmed the dismissal. Then last year, the entire court rejected in-bank review. A police officer killed a completely innocent man because of the officer's inexcusable mistake. He escaped criminal prosecution, and then he even escaped civil liability because of a little-known judge-made legal doctrine called qualified immunity. Sadly, this was but one injustice caused by the misguided doctrine. It will not be the last, but there's a solution. Judges created qualified immunity, and they can end it. It's past time to impose true accountability on public servants who violate citizens' constitutional rights. First, some background. Since 1871, federal law permitted Americans to file lawsuits against public officials who violate their constitutional rights. It's a powerful tool that essentially deputizes members of the public to defend their own liberties. The relevant statutory language seems quite clear. Every person who is under color of any statute, ordinance, or regulation, custom, or usage of any state or territory or District of Columbia, subjects or causes to be subject any citizen of the United States or other persons within the jurisdiction thereof to be deprived of any rights, privileges, or amenities secured by the Constitution and laws shall be liable to the party injured in the action at the lawsuit in equity or other property proceeding for redress, emphasis added. However, after generations of judges have interpreted the statute, the phrase shall be liable has come to mean may occasionally be liable. As the New Republic Matt Ford outlines in an excellent extended essay on qualified immunity, courts originally permit public officials to cite traditional common law defense of good faith and reasonableness to overcome Section 1983 lawsuits. So there's the loophole that they're using to get out of being held accountable for killing a citizen. In 1982, however, the law changed in a case called Harlow and Fitzgerald. The Supreme Court concocted the modern doctrine of qualified immunity, designed in part to encourage the vigorous exercise of official authority. The court redesigned doctrine protected public officials insofar as their conduct does not violate clearly established statutory or constitutional right of which a reasonable person would have known. And how does one determine what is clearly established right? After all, the First Amendment seems relatively clearly established, as does the Fourth Amendment and the Second and the Sixth. But no, as the doctrine developed to prove that a right is clearly established, the plaintiff generally had to find and cite a remarkably similar case with nearly identical facts decided by a court of controlling jurisdiction. So when Andrew Scott estate sought compensation for his death, it didn't just have to prove that the officer had no warrant knocking on the wrong door and gunned down an innocent man in his own home. It also had to find another case with facts similar to the undisputed facts in Scott's case. Oh, and the comparison had to be particularized. High levels of generality simply won't do. In a recent concurrence, newly confirmed Fifth Circuit Judge Don Willett launched a blistering attack on qualified immunity. So in some observers, qualified immunity smacks of unqualified impunity, letting public officials duck consequences for bad behavior, no matter how palpably unreasonably, as long as they were the first to behave badly. Merely proving a constitutional deprivation doesn't cut it. Plaintiffs must cite functionality identical precedent that places the legal question beyond debate to every reasonable officer. Put differently, it's immaterial that someone acts unconstitutionally if no prior case found such misconduct unlawful. So I encourage you to read the entire concurrence, but we're not going to read this because this is very, very long. Well, no, it's not. No, it's not. Yes, it is. It's pretty long. So they're working on to end qualified immunity because that is why the cop that shot Michael Brown got off qualified immunity. Other cops that got off, they're using qualified immunity. So qualified immunity excuses them from getting sued for harming a person or killing a person. So they're trying to end qualified immunity and hold government officials to the ladder of the law. Let's keep talking about this. Like, share, subscribe. Salome B. Have a great day.